The High Courts and Subordinate Courts, Chapter 5 of Civics. High Courts are provided to each state of a country. There are near about 25 High Courts in India. High Courts stand at the middle level or at the second level in the hierarchy of the judiciary system, that is, under the Supreme Court. High Courts function from the state as headquarters and are followed by the subordinate courts, which start from the district level. Now, in the Union territories, only Delhi has a high court of its own, whereas Goa, Daman and Diu have a judicial commissioner, and other Union territories come under different jurisdiction of different high courts. For example, Pondicherry comes or falls into Madras High Court. High courts are established depending on the area of population, on the area or population to which it has to serve or the amount of work it has to handle. Therefore, you can see the number of high courts, even though we say that high courts are provided for each state, yet is less than the number of states in India. So, it means like any particular state which has got less amount of work and is less populated or say thinly populated, then in such cases two states can be combined and the constitution provides for a common high court. Therefore, this reduces the number of high courts in India, which rather unequal to the state number of states. Let us look into what is this high court composed or comprised of. High court consists of a chief justice and such other judges who are all appointed by the President of India time to time. So, the President of India, as per the need be, can from time to time extend the number of judges of the High Court. Qualifications to become a judge of High Court. So, here it comes that he or she should be a citizen of India, he or she should not be over 62 years of age, he or she must have held a judicial office in the territory of India for at least 10 years or must have been an advocate of a high court for at least 10 years. Apart from this, the qualification also speaks about that he should have been an eminent jurist, which was added by the 42nd Amendment Act 1976 and was again omitted by 44th Amendment Act of 1978. These judges of the High Court, including the Chief Justice, are all appointed by the President of India in consultation with the Chief Justice of Supreme Court and the Governor of the concerned state and the Chief Justice of the High Court. Now let me just segregate it. In case of the appointment of the Chief Justice of High Court, President consults the Chief Justice of the Supreme Court and the Governor of the concerned state only. Whereas for the other judges to be appointed in the High Court, President undergoes for the consultation with the Chief Justice of India, the Governor of the state and the Chief Justice of the High Court. A question might arise here, why Governor of the concerned state is included in this appointment? So let me tell you, Governor has got a one of his judicial function as oath giving ceremony. Here the Chief Justice and judges of the High Court take the oath. So he is the one who, without President appoints them, but Governor is the one who gives the oath. So this oath giving ceremony is basically held with governor. Now moving on to the lower courts, let us just have a look into the hierarchy. As we have already seen a hierarchy in the previous chapter of Supreme Court relating to the Supreme Court, then High Court and the subordinate courts, here we move on to much more detailed hierarchy of the subordinate or the lower courts. Subordinate court are categorized again under civil courts, criminal courts and revenue courts. Now as per our syllabus, we are to deal or discuss with the civil courts and the criminal courts. Civil courts and criminal courts, they both are headed by the district court. That means they are the two different categories under the district court. The highest court under civil court is again the civil court is headed by a district judge and the criminal court is headed or presided by a sessions judge. Now both these, a district judge and sessions judge, they are not two persons. This is actually one person. So it is one judge, but it depends on what he is dealing with. That is, if the judge is dealing with a civil case. What are civil cases? Civil cases will include cases related to breach of marriage or divorce or any other personal matter, and if the judge is considering or dealing with some civil case, then he is called to be district judge, and the court where the case is considered is called to be the civil court. Whereas if the same person takes over or handles a criminal case may be relating to theft, robbery, murder or so. So in that case, the same person will be now known as sessions judge, and the court where this case is considered will be called as a criminal court. So this is very important. You just need to be very clear about this and not create any confusion. So I repeat, a same judge when hears a civil case is called a district judge and the court is called civil court, whereas when he hears a criminal case, he is called sessions judge and the court is called the criminal court. Now let us understand what is district court. The district courts of India are established by the respective state governments in India for every district. Now as we initiated the chapter with this information that every state is given out with a high court by the constitution, similarly again in the state every district is given this district court by their concerned state governments. So here again the state governments can give this for every one or more districts together, again taking into account the number of cases or population distribution in the district. These courts administer justice in India at a district level. So we can say the jurisdiction of a district court lies only within that particular district. So this is what a district court means. The subordinate courts. Here the hierarchy says it's a state. State has got districts and then district has to deal with civil, criminal and revenue courts. So already we have seen one hierarchy. So these courts, they all function at the district level and below. The organization and the structure of subordinate courts are all uniform. Every district of a state has a civil, criminal and revenue courts. Let us learn about what is civil court. Civil court is a court which deals with matters or cases of marriage, divorce, will, land, property guardianship, etc. So in a district, the highest civil court happens to be court of the district judge. The judge who decides on a civil case, as per we have already discussed, is known as district judge. A district judge is appointed by the governor with consultation of the Chief Justice of the High Court of that particular state. Of that particular state means of the state of where that district belongs to. And the district judge exercises his or her administrative control over all civil courts in the district. Okay, this is all about the civil court. Moving on to the criminal courts. Criminal courts deal with assault, murder, pickpocketing, dacoity, robbery, etc. All sorts of crime we can say. Now here the highest criminal court of the district is known to be the Sessions Court, and here it is presided or headed by a sessions judge who is again appointed in the same manner, that is by the governor, in consultation with the Chief Justice of High Court of the concerned state. A sessions judge does not perform any sort of an administrative function. Now we come to the basic distinction or differences between court of district judge and sessions court. So as I said, this court of district judge is the highest civil court of the district, and sessions court is the highest criminal court of the district. Very important to be noted for a sure short question. Court of district judge is presided by a district judge. Sessions court is presided by a sessions judge, and remember they both are the same person, only the dealings of the case defines them as per the case they are defined, whether district judge or sessions judge. Now the district judge and additional district judges are appointed by governor in consultation with the Chief Justice of High Court of the concerned state, whereas session judge and additional session judges are appointed by governor in consultation with the Chief Justice of High Court of the concerned state. Now one thing I'll add it here. Under the appointments, we just went through two appointments, that is the Chief Justice and other judges. But apart from them, that is there are two other types of judges who are also appointed. They are additional judges and acting judges. Now who are additional judges and who are acting judges? Additional judges are those who are added, who are appointed by the president as per the requirement of the High Court. Now for example, a particular High Court is overburdened with cases, and therefore number of judges are falling short. So here additional judges can be appointed in order to lessen the burden of the High Court, and this is done on a temporary basis or a temporary period which is not more than 2 years for only clearing the pending cases. So they are called additional judges. So judges, those who are in addition to the existing, are again appointed, right? The other category I said was acting judges. Acting judges are those who take the place of the permanent judge. Now for example, in case a judge falls sick or is out on a trip, or in any case is away from his or her duties, then in that case president can appoint another judge again on a temporary basis, that is till the time the permanent judge is back and resumes back to his work. So this is done by the president, and here this judge is known to be an acting judge. So we have the Chief Justice in the High Court, we have other judges, and apart from other judges, that besides other judges, we have additional and acting judges. Now then we have the third point as, the fourth point as the district judge, the court of district judge handles civil cases like land, property, marriage, divorce, will, etc. And criminal sessions court deals with the criminal cases like murder, dacoity, pickpocketing and theft. District judge also acts as a deputy commissioner and district collector and maintains law and order and supervises the collection of revenue and taxes in the district. So again here, deputy commissioner and district collector, they are the same. Many of the states, they are known to be the same. They are some, in some places, if they are known to be deputy commissioner, then some other places they are called as district collector. And since it is all about collection of revenue and the taxes in the district, therefore district collector is the name which they are referred with. Under Sessions Court, the Sessions Judge does not perform any such administrative functions. This is what all about distinction or differences between a district judge and a Sessions Judge, or a court of district judge and a Sessions Court. Now let us look into the root level subordinate court. Root level, this starts from the absolutely ground zero level, that is, the name itself will speak like Lok Adalat. Lok Adalat is nothing but people's court, and this is just itself, these are the courts which itself directly reach the people and hear the cases. Basically, this is to go through the grievances of the people and hear them and then solve it out. For those who cannot afford, those who cannot afford to move on to high court, to the concerned capital of a state, or they are basically in the village or the village areas and all. So it is an alternative dispute redressal mechanism where disputes or cases pending on panchayat or at pre-litigation stage are settled amicably. Amicably, that is, people are made sit across the table, and with the help of a panel, things or cases are solved out. So here there was a statutory status given under Legal Services Authorities Act in the year 1987, through which we get this Lok Adalat. This Lok Adalats shall be deemed to be decrees of a civil court, and they shall be binding on the parties to the disputes. Here cases are solved informally and cordially with the involvement of conflicting parties. That is, as I said, sitting across the table, matters are tried to be solved. So Lok Adalat, People's Court, usually for the people, and for solving out of the grievances of the people at the root level. Then we need to know a little bit about what is the advantages of the Lok Adalat. The advantages are basically this provides quick justice to those who can't afford. That is, afford for fees and all, and let me tell you, this is all free of cost. And therefore the first advantage goes like it is a quick justice to those who can't afford for it. So these actually play a very important role basically in settling down some petty issues, of the family feuds and the disputes between the neighbors, and the minor cases of assault, injury, by settling the disputes through compromise and all. So since they work in the spirit of compromise and understanding, both the parties even feel satisfied, and they are made across the table. So right in the picture you can see there's a panel sitting, and the interrogation, the interaction among the panel and the two parties brings out the solution. Then it says like Lok Adalats deliver justice fast and eliminates high cost. So quite good. It gives away the justice quite fast because there are no instances like getting the hearings and dates and change of dates and wait for the next hearing and all. So any person can move to Lok Adalat by just an application on a plain paper or using the format which is available with legal service authorities, and can for sure expect speedy justice. Lok Adalats, as it says, also reduce the workload of other courts, enabling them to deal with more serious matters. So, as I said initially, all these petty issues back at the village area, which will unnecessarily be a wastage of time if taken all the way to the high courts, and maybe some other important matters might not be brought in, which are of public importance. So, in order to avoid this, Lok Adalats here can be said that they reduce the workload of other courts. Other courts here is referring to high courts basically, or say Supreme Court, and also delay in higher courts. In higher courts basically there are so many cases and also it's quite delayed there, whereas in Lok Adalats they are quite faster in giving away their decisions. Lok Adalats all in all promote social justice to weaker sections by providing legal aid. So it is like they are very much effective in providing proper legal aid to the weaker sections, since they are hardly aware about their rights or say their facilities that they have. So these are the advantages of Lok Adalats, and end of the chapter. Thank you, children.